All right, good afternoon, everyone. It is noon on the button here. Thank you for joining the 12 Points November webinar. My name is Christopher Cahill, a partner at 12 Points running the Family Office Services Group. We're going to give folks another couple of minutes. We had 200 plus people register for this event today. We're super excited about it. They're trickling in here at the moment. Want to just give everybody a couple of more minutes, but we want to be respectful of your time as well. So we will begin in just a moment. So we've got Amanda Mulhall on the line with us here. So we'll just give you another minute or so, and then we'll let it rip. All right, so bear with us for a moment. And again, we're just going to give folks another couple of seconds here to join. We've got numbers rolling through pretty fast and furious, so we'll get going momentarily here, and thank you all for joining us. All right, so let's just get going here. For those of you that came in timely, we want to make sure that we're effective and efficient with our time and respectful of yours. Others will continue to join in. I'm sure we've got a bunch of people here today, which is wonderful. So again, thank you for joining. My name is Christopher Cahill. I'm a partner here at 12 Points. This is my lovely photograph. I run the Family Office Services Group, as I said a moment ago. What I'm really known for is helping successful business owners that are looking to make a lasting generational impact with their wealth. Many of these are family-owned businesses, closely held businesses, lots of real estate holdings, people with significant wealth. I'm an attorney by training and background, a CFP and a chartered advisor in philanthropy. I practiced law for a number of years before pivoting into the world of financial services. I'm really happy to have with me today Amanda Mulhall from Mulhall and, pardon me, one second, Withrow here from Medfield's offices. Amanda, why don't you introduce yourself here?
Sure, thanks, Chris. Thank you so much for having me today on the webinar. My name is Amanda Mulhall. I'm a partner in Mulhall Withrow. We are an estate planning and family law firm located in Medfield. I really focus my practice on sort of holistic planning for families, many of whom have little kids, but really growing wealth. And many of my clients are putting together their very first estate plan when I'm meeting with them. So the topic today that we're going to talk about, sort of the foundational documents, is something that I talk about day in and day out with my clients.
Perfect. Thank you, Amanda. And probably appropriate to just articulate here that whilst many of the 200 plus of you that are on this webinar today are located in Massachusetts, we are as well. We will be touching on some Mass-specific rules and regs, but this is generally applicable information for those of you that are outside of the Commonwealth. So, don't fear. We'll be touching on things that will be generally applicable to you if you're in New York or wherever. So I think that's just important. And did you have anything else that you wanted to add to that, Amanda, before we got going?
Yeah, and just a sort of a general note that this, what we're talking about today is a sort of large concept where, it's not any specific legal advice. So if you wanted to jump into doing your own estate plan, absolutely meet with an attorney to talk through your individual case, your assets, your family, to really get the right plan for you.
Perfect, thank you. So without further ado, let's spend a second talking about the new changes. Well, here's an overview, excuse me. The next slide is the new changes. So this is what we're going to be discussing. We're going to be talking about, the importance of wills, revocable/living trusts, powers of attorney, healthcare proxies and medical directives, the HIPAA authorizations, irrevocable trusts, and some other strategies, prenuptial agreements, etc. But without further ado, we had a big change in the Massachusetts estate tax law over the last year or so here. Amanda, you want to kind of take us through this?
Sure. So Massachusetts is one of 12 states, I believe, that has an estate tax. So this doesn't apply to every state, but here in Massachusetts, up until 2023, we had a $1 million filing threshold amount, meaning that if you passed away with under $1 million, you didn't have to pay any estate taxes to Massachusetts. But if you passed away with above 1 million, it triggered the tax. So the tax applied to every asset you had from $1 up to the last dollar. So that really changed substantially about 2 years ago. They've raised the filing threshold amount to $2 million and really made it a true exemption, meaning that if you surpass $2 million worth of assets, the tax only applies to the assets above 2 million. It's not inclusive of the entire estate. So that was a pretty generous gift here to the taxpayer in Massachusetts. One sort of caveat to the Massachusetts estate tax is that married couples for federal estate tax purposes and in many other states can automatically combine their exemption amounts to put them together to get $4 million of exemption. You're not able to do that in Massachusetts automatically, but it does give us a very good planning opportunity, which we're going to talk about a little bit more later. So that's one sort of tricky thing in Massachusetts to know about, but we can really do some impactful planning with the new estate tax law.
Yeah, and I would just simply add there, it's amazing that, you know, it was quote generous, right? It was 100% increase from $1 million to 2 million. But the reality is that the $1 million was one of the smallest exemptions in the country. And there are many states like Connecticut, for instance, where they remain coupled to the federal exemption, and the federal estate tax exemption is set to increase on January 1st to $15 million per person or $30 million per married couple. So when you consider that we went from 1/2 to 2/4, good. It's not so great when you consider there's other places that you could pass 30 million without taxes. So it is.
It's all relative.
It's all relative, exactly. But you also get the beauty of living in Massachusetts, which is great. So there are planning strategies, and we will talk about that here in a moment. But let's just kind of get into the world of wills. If people think about estate planning, they often think that, you know, the will is the operative document. Let's talk about that, Amanda.
Yeah, everybody, you know, is waiting for the reading of the will, right, when the family member passes away. That's what they have in their head when they first meet with me. So wills are important documents, but they don't do a whole lot, believe it or not. So a will is really the document where you can name beneficiaries, who you would like to receive your assets when you pass away. And by assets, I'm really talking about probate assets. So assets owned in the name of the decedent, the person who passed away. So typically that's real estate, that's bank accounts, that could be brokerage accounts. Assets that are beneficiary designated, traditionally those are retirement accounts and life insurance policies. Those tend to pass outside of probate if you've properly named a beneficiary. So wills cover really anything owned in the name of the decedent. You can also appoint guardians for minor children or incapacitated persons in your will as well. A large part of my practice is comprehensive guardianship planning. So one place where we do that is in your will. There are different types of wills. Simple wills is the one that most people think of, which is essentially saying I would like my assets to go equally in equal shares to my kids outright. They split it in half and they go their separate ways. Pour over wills are wills that are used in conjunction with trusts, and we're going to talk about trusts a little bit later, but we want the documents to work together. So it's important from sort of a comprehensive standpoint that we are making sure that the will is working together with a trust to make sure that any of the assets owned by a decedent, once they pass through probate, are ending up in a trust, and that's called a pour over will. Wills have certain requirements in order for them to be valid. You know, some people say, like, I wrote something on the back of a napkin, is that good enough? Well, not necessarily, right? There are some requirements to make sure that the person who made the will was over the age of 18, of sound mind, under no duress, that is witnessed by two competent individuals, so of age and of sound mind as well. So there are some specific requirements to be able to have a valid will that is honored by the court.
Perfect, thank you. And yeah, it's funny, your comment about the reading of the will makes me think of all those, you know, masterpiece mysteries and Agatha Christie's where they all sit around waiting. It doesn't often happen like that.
No, not quite.
So here we are into the world of living trusts, revocable trusts. This is that tag-along document that Amanda was discussing a moment ago, and this in conjunction with the pour over will is really like the engine, if you will, for comprehensive estate planning. One of the most important documents that you can have, candidly. So let's talk about this.
Yeah, so many people, when they meet with me for the first time, their only exposure to trust really is sort of like in the news, maybe sort of more newsworthy type things, like maybe, you know, the Roger Ailes and Sumner Redstones of the world, when they're passing their media empires, there's always some sort of controversy of, you know, who are the beneficiaries of the trust? Who are the trustees of the trust? So most people think of trusts as for really wealthy or influential individuals. That's not really the case. Trusts actually can work for typical families as well, to do a lot of work. Essentially, all trusts is their agreements, right? They're agreements between three parties: the grantor, which is the creator of the trust; the trustees, which is the people who manage the assets in the trust; and the beneficiaries, the people who get to use the assets in the trust. Most of the time while you're still living, you can be in all three of those roles in your revocable trust. So you can use your assets however you want. You can change the trust or revoke it. So they're very flexible documents. What they are used for is they allow the assets that otherwise are named sort of in the will that would pass through probate, if we can move those into the name of a trust during the grantor's lifetime, then we can pass those assets to the beneficiaries without having to go through the court. So that's one major benefit of using revocable trusts. That saves time. It saves a lot of money. It keeps things private. So if privacy is something that's important to you, it also gives you a lot more control over what happens to the assets ultimately. So for families who might have little kids, right, who are under 18, or maybe a child with a disability, right, it gives you a lot more control over who is managing assets and when they will ultimately pass to the beneficiaries. We can also use trusts to reduce Massachusetts estate taxes. I was talking about earlier how married couples, you can't put those two exemption amounts together in Massachusetts automatically. We use trusts to get that outcome. We are strategic about how we structure them, and we instruct the trustees to make certain tax elections that give us the outcome of combining those $2 million exemptions to make it 4. So that's another great way to preserve even more of the assets by leveraging revocable trusts. Cons, right? That's a question I get a lot too. Why doesn't everybody have this? Why doesn't I get that question a lot? What are the downside? What's the catch? There's a cost to setting them up, of course. They're a little bit more expensive to implement than wills alone. And there's a little bit of work that needs to be done because there needs to be the actual retitling of the assets. So the real estate, the bank accounts, the brokerage accounts, business interests for business owners. That's really where the partnership with wealth advisors is really valuable to an estate plan, because your attorney can coordinate with your wealth advisor so that everybody is on the same page about how assets should be retitled. So that's really where that valuable relationship can come into play, to make sure your whole team is getting in place.
Thanks, Amanda. And, I would simply add one of the biggest pros that I see here in the world of the Rev Trusts is providing for management of assets, not only at your passing, which is critical, obviously, but during your lifetime. And the reality is that I've seen many clients that would have benefited from having assets in a trust. They came to us afterwards, and they've got a family member that's incapacitated now. They didn't fund the trusts appropriately beforehand, and they're really stuck having a power of attorney over somebody that's disabled. And as we get to we'll talk about this more in the next section on durables, but what is amazing to me is how you uniquely and across the board, financial institutions really dislike powers of attorney.
Yes.
I can't tell you how oftentimes I see a client go in with a power of attorney to a bank or a financial institution. They break out the legal team and say, hey, look at this thing. Is this right? Should we use it? Shouldn't we use it? And they'll do everything they can to avoid giving power to the power holder to make decisions. Whereas if you have your assets all in a revocable trust and you're the trustee, say, and you're no longer able to do it, simply have a new trustee, the successor trustee. They bop into the bank or financial institution and they roll out the red carpet. They want to give them milk and cookies, and they'll, for whatever reason, they'll give more credence and credibility to a trustee than they ever will in a power holder under a durable power. So unfortunately, that's a really often overlooked function of the Rev Trusts, and hope that nobody that you know about, or yourself for that matter, gets incapacitated and needs to rely upon it. But having the assets in the trust far outweighs having just a durable power.
Yeah, I'm really glad that you mentioned that, Chris, because another sort of piggybacking off of that point, you could choose to have, more than one trustee serving. So you can choose your successor trustees. So who you want to step in to manage your assets for you. If you wanted that to be more than one person, you can certainly do that. Powers of attorney, we really, legally, could you have more than one? Yes. Is that a good idea? No, that is almost an absolute no-go from the financial institutions, in my experience.
Yep. No, agreed. And it's funny, people get squirrely about powers of attorney too, signing them. I have a client that's an attorney themselves, and they don't do trust and estate planning, but they're in the midst of updating their documents, and I've got a call with their attorney this week, and them going over everything. And one of the things that she was really concerned about was this power of attorney giving authorization to folks like right now. And she said, "Is that normal?" I said, "It is. That's why you got to be really thoughtful about who you give the power to." And she said, "Well, can't we just have it be applicable at my incapacity later?" And I said, "Yes, we could. That's what's called the springing power of appointment." I will tell you that creates a whole layer of other issues for people, because now we need your doctor or somebody to come in and say, hey, this person's in fact incapacitated or incompetent. And that just puts another layer over top of the analysis to begin with. So if you're not comfortable signing a power of attorney to the person that you're contemplating right now, I would submit to you that you might be giving it to the wrong person. Let's talk broadly about what we're doing here with these documents, Amanda.
Yeah, so what a power of attorney is, it is giving someone else the ability to make legal and financial decisions for you, and that is active upon signing the document, right? Like Chris, you were just saying, unless it's a springing power of attorney, which is complicated for the reasons you just stated. So really a durable power of attorney, a durable general power of attorney covers sort of day-to-day operations, right? So say the agent could pay the principal's bills or file taxes on their behalf, or connected with legal decisions, say someone was incapacitated and because they got into a car accident, right, and somebody sued them, the agent could step in the principal's shoes and respond to that lawsuit. So those are some examples of what someone could do under a power of attorney. There's different kinds, though. We can make them a little bit more specific. Non-durable, meaning that it stops working once the principal becomes incapacitated. That sort of is almost like the inverse of what most people think the power of attorney is for. Since when you think you would need someone is when you become incapacitated, but non-durable is sort of the opposite. There's also limited and special powers of attorney. So that might be, say you have a real estate closing, across the country and you just can't get there. You might give somebody a limited power of attorney to sign that document for you in just that very limited capacity. So we can sort of change the scope of the power of attorney depending on the circumstances.
Great point. Thank you for that. And that's really where many people have come into a durable. Their first time is, maybe buying or selling a home. So great observation there. Let's talk about the other side of this, healthcare and medical directives.
Sure. So a healthcare proxy, it's a similar idea to the power of attorney, but it's related to healthcare decisions. And this only comes into play if the principal is incapacitated, right? So as long as you know the nature of the decisions that you are making and you can communicate them, you will make your own healthcare decisions for yourself. If you lose the ability to communicate or do not know the nature of your decisions, that's when your agent can step in and consent to a new course of treatment or a new medication, something like that, that you otherwise would do for yourself. So together with that, living wills and advanced medical directives are non-binding documents. In Massachusetts, specifically, you're not able to create a binding living will, but the purpose of this document is to tell your healthcare agent what you would want them to do for you if you were in a terminal condition or persistent vegetative state and you were not going to regain any meaningful life. This is to help your healthcare proxy sort of make a determination in that circumstance. So again, they're more like memoranda. They are not legally binding. So it's really up to your healthcare agent to still make any sort of call like that for you.
And that's a great point, Amanda. I mean, the reality is that these are conversations, right? So if you're contemplating updating or redoing or implementing your estate plan maybe for the first time, the folks that you're going to be giving these powers to, whether it's the durable power of attorney holder, whether it's the healthcare agent, or whether it's a trustee, having conversations with them about what you view as important and how you would want them to act in advance. Oftentimes, those are just critical conversations, right? I mean, the reality is that you're likely appointing somebody that's never done this before. They're not really going to know how to act. They might be a family member or a close friend, in which case they'll be bereft if they have to make really hard decisions for you. But you providing them with the okay and the guidance and the rules of the road as to what you would like in advance really can help lessen the stress on them and have them have more confidence in the conviction of the decisions that they need to make. So those are really important conversations, as are just the obvious things. If you're talking about life and death, where would you want to be buried? Like, how would you want your service to be handled? Those sorts of things. And, maybe not as necessary for a young family getting their first set of documents, but for people that are aging and, maybe on the back nine of their life, so to speak, important conversations, right?
Yeah, absolutely. Still important to have something like a living will, even if you do have those conversations, because living wills, in addition to just providing, guidance, They also helped to insulate your agent under your healthcare proxy, because if they're going to make a decision like that for you, that's sort of a really large magnitude, they will likely at some point get pushback from somebody else, right? Maybe their sibling or another family member, about the decision to perhaps take you off of life-sustaining treatment. So if they have a written directive from you that they can point to and just simply say that they are following your wishes, the hope is that they will be able to not only sort of live with that decision themselves, but also, you know, other people will as well. So it does help to sort of insulate your agent from any of that sort of criticism. That can be helpful too.
No, it's a really great point. All right, so now let's talk about the old HIPAA authorizations here. Oops, sorry.
Yeah, so HIPAA sort of goes hand in glove with the healthcare documents. HIPAA is a medical privacy law. The part of it is it's sort of a pretty robust law, but the part related to estate planning is really your healthcare providers are not able to share any of your medical information with anyone except you. You know, of course, that sort of varies depending on the institution and the physician or medical staff. But, you know, by the book, the black letter law says they are really not able to talk to anyone, including a spouse or a child or anything about the patient. So we want to ensure that the healthcare agent has access to your medical information if they're going to make decisions about you and for you. So having, you know, an appointment as a healthcare agent alone does not waive your HIPAA protections. So we want to make sure that that is really spelled out for any healthcare providers, so that they know that they are permitted to release your medical information to the agent. So we always prepare a HIPAA waiver. That also is active upon signing it. So sort of similar to the conversation we were having about the power of attorney, where the power is sort of vested immediately upon executing the document, make sure that whoever you are appointing as your healthcare agent, even if they can't act right now because you are, you know, alive and well and can make your own decisions, technically you have waived your HIPAA protections related to that agent right away. So something to consider as you are choosing your healthcare agent.
No, thank you for that. That's really, really important. You can't make decisions if you don't have information, right?
Mm-hmm.
So here, irrevocable trust. So we talked a little bit ago about the importance of revocable trusts, right? One of the things that I'm not sure we really articulated well with regard to the revocable trust is that it's just that, revocable. Whilst you're competent and during your lifetime, you can change it, right? So that document in all essences and for all intents and purposes is like your alter ego. There are trusts that are utilized for all manner of planning strategies and techniques that are irrevocable, meaning you can't change them. And the beauty of some of these irrevocable trusts is that it allows us to really make use of planning techniques and topics to minimize estate taxes, to provide for certain outcomes, etc. So you know, let's kind of talk broadly about irrev trusts. I mean, there's so many flavors. It's like a Baskin-Robbins store, right? There's so many different types of trusts. We won't get into all of them, but let's just talk about why you would want to use them and you know, for the masses here, Amanda.
Yeah, there's sort of two major buckets that would drive someone to create an irrevocable trust. One is asset protection, the other is tax planning. So once you set these up, you can think of them as similar to maybe a corporation or a third party, like another person. It's a totally separate entity that has its own tax ID number. It's totally separate from the grantor, whereas revocable trusts essentially, you know, are the grantor. There's no difference between the level of control the grantor has over the assets, which is different than an irrevocable trust. So moving assets into an irrevocable trust can offload that asset from the grantor's taxable estate. So that's a way to get assets out of your name, so they're not subject to estate taxes when you pass away. I see life insurance trusts in all caps on our slide here. Life insurance is an excellent asset to plan with using irrevocable trusts because they're often, the payout can be pretty large, which can increase the tax liability substantially. So if we can use an irrevocable trust to own a life insurance policy and get it out of your taxable estate, that can preserve a lot of assets for the beneficiaries. You can also use them for long-term care planning. So a lot of folks may move real estate into an irrevocable trust to ensure that the individual qualifies for Medicaid that they otherwise wouldn't, because that's means tested. You can only have a certain number of assets in order to qualify. So moving some assets out of an estate and also making them out of the reach of any Medicaid clawbacks or Mass Health here in Massachusetts is a way to preserve more assets as well. Downsides, right, is once you make that gift into an irrevocable trust, it doesn't belong to you anymore, right? It's gone. It belongs to the trust managed by trustees. You don't have any control or right to that asset anymore. And you really cannot change the terms of the trust at all. There are ways to make administrative amendments. Yes, you can get consent of beneficiaries and change them. There's another thing called decanting, which is sort of moving assets into a whole new trust. But by and large, the rule is that you can't change the terms of an irrevocable trust once it's been established.
Great stuff. And yeah, and there's just so many iterations of these IRREV trusts that we use day in and day out here at 12 Points, and in conjunction with Amanda, her firm, and others. There's just way too many to really dive into, but I think we hit on the top really, the insurance trusts, Medicaid trusts, and yeah, there's just a tremendous tool in planning. So as we continue on down here, this is a really important component. As kids become senior, graduate high school and they're going off to college or wherever they're going to go in their career, you really got to make sure that they have documents in place. You want to take us through this, Amanda?
Yeah, so a lot of my clients who I work with, and they have little kids, and then their kids become bigger kids, and then finally they are going off to college. It's really important that we get some of these documents in place. Healthcare proxy and HIPAA waivers, I know, keep moms and dads up at night, because if your child is 18 and something happens to them while they're at school, you really can't call up health services or the hospital and find out what's going on with them, because they're an adult and you don't have the right to that information anymore from a legal standpoint. So having your child sign a healthcare proxy and HIPAA waiver is really important, and having them actually file that with health services is pretty important too. Power of attorney, your kids at school, they need some money, they've overdrawn their bank account, who knows what happens, or being able to actually talk to the school about the child's grades or what's happening with their tuition is due. People don't realize that they are not able to get any information from the schools. So having that set up, and then of course a simple will, right? So really nothing too complex typically for 18-year-olds, but just making sure they have something in place in case anything happened.
Yeah, perfect. No, really, really important. And this is a nice thing to remind your friends and family about, when their children become 18, the age of majority here in Massachusetts. It's really important that they reach out to an attorney like Amanda and get this stuff done, because it will prevent a lot of heartache on top of an already stressful situation should something come to be where you would actually need these documents. And we're just going to touch on this one here as we round around the end here. So prenuptial agreements, oftentimes we'll have wealthy clients that will come to us and say, hey, great news, our daughter or son is just getting engaged, and would love to figure out how we can protect our wealth from our soon-to-be daughter-in-law or son-in-law. So let's talk broadly about these, Amanda, as we round out the time here.
Sure. Prenuptial agreements are really important to do just that. They're really polarizing for
Oh, yeah.
clients. Some people really see utility in them. Some people think they're just, preparing for divorce before you even get married. So they're really, people think all different ways about these. But really what they can do is they set out what everyone has, assets and debts, what you want to happen to those things. If the marriage ever ended, can everyone just walk away and take what they came with and then figure out whatever happened in between? You can also include expected inheritances in prenuptial agreements as well. So to Chris, your point about maybe wealthy clients wanting to make sure that any expectancies that their children have are really outlined is really important. It can also waive certain rights that spouses have. So, for example, like alimony rights, the parties could agree from the outset, we're not going to, ask for alimony on a divorce. We're just going to go our separate ways. And then I mentioned debt as well, right? So any debt that you come into a marriage with, it would be important to, or I guess your spouse comes in with, you want to make sure that if the marriage ends, that you're not taking on any of their personal debt, that you can really separate that out. So prenuptial agreements certainly worth the conversation. There are also things called postnuptial agreements. It's better to do the prenuptial, which is before the marriage, because there's no presumption that one party was sort of strong-armed into signing the agreement, where they're looked at a little bit more skeptically when they're after the marriage.
Yeah, and I would simply add to that pulling off a postnuptial agreement is going to cost you a pretty penny, A, and B, they are looked on askant by the courts. The other thing to just remember on these prenups, back when I practiced, I had several situations where people would walk in the door, long-standing clients of the firm. They'd walk in and they'd say, "Hey, great news, Joey's getting married." "Oh, really? When?" "Saturday." "Can we do a prenup?" Right. No, we cannot. You really need to put some time and disclosure between the signing of the prenup and the event, because otherwise it's just too much duress, and any court in the country would set aside a prenup that was done within that time, a short time frame. They're going to say that the other party didn't have the opportunity to really review this. They didn't have the time to think about it. They had already invited everybody. Everybody was, financially committed to this wedding. Those are just a recipe for disaster. So know that these are out there. Hopefully, you're not going to be relying upon that. You're going to have a nice long-term marriage, etc. So we're here at the end. Amanda, I can't thank you enough. Wonderful job as always. Great to speak with you. Again, congratulations on the birth of your daughter. Here's Amanda's contact information on the screen here. If you have interest in talking about estate planning, by all means, reach out to her. Of course, you can see my information here as well, Chris at 12pointswealth.com or simply 12points.com. The two of us would welcome the opportunity to speak to any of you about your thoughts, issues, concerns about estate planning. Amanda, thank you. To all of you, really appreciate you joining us today. Hope you have a wonderful Tuesday, and happy Thanksgiving to everybody in advance.
Thank you, Chris. It was great as always. Appreciate the opportunity.
Be well, Amanda. Thank you.